Good morning, everyone. Welcome to the third installment of the Doors and Dialogue series. I'm Jay Larry, A&S class of 2014, law class of 2017, and current LAVA president, and I will be moderating today's panel. Doors and Dialogue is a series of town hall style events planned in partnership with the Office for Equity, Diversity, and Inclusion, and the Office for Inclusive Excellence. And each event in the series is hosted by a different affinity group. We at LAVA hope that you have the opportunity to join the Association of Vanderbilt Black Alumni and the Vanderbilt Association of Hispanic and Latina alumni for their insightful and enlightening Doors and Dialogue events over the past few months. And we are, of course, glad to welcome you to our event. With over 400 members to our name, the LGBTQIA+ Association for Vanderbilt Alumni, or LAVA, focuses on preserving and celebrating the history of the LGBTQIA+ community on Vanderbilt's campus, building and strengthening ties among alumni, providing mentorship and networking opportunities for our alumni, and advocating for current students. By the way, if you're a member of the community and want to join LAVA and also get a free Vanderbilt rainbow mug, please feel free to use the sign up that we will drop in the sign up link we'll drop in the chat. So as we sat down to plan this event, we wanted to select a topic we felt would be relevant to LGBTQIA+ Doors on and off the university's campus. We decided to pair two topics: Bostock v. Clayton County, the 2020 Supreme Court case that held that discrimination on the basis of an individual's sexual orientation or gender identity violates Title VII of the Civil Rights Act of 1964, and the rise of anti-LGBTQIA+ legislation at the state level would be the perfect things to cover, as they seem to fit the bill. I am joined by a panel of esteemed experts in their fields. We have Tyler Bishop, a 2015 Vandy alum who was involved in Bostock through Stanford Law School's Supreme Court Clinic. Anita Genius, director of the Office of Equal Opportunity and Access. Rob Nelson, interim director of LGBTQI+ Life, and Professor Matthew Shaw, who is an assistant professor of public policy and education and assistant professor of law at Vanderbilt. I'm sure by now you're thinking, surely this guy will be quiet and let the panel talk. You're half right. I will introduce each panelist and then get out of the way and let them share their insights on the topics we're going to cover. So we will get started with Tyler. As I briefly mentioned, Tyler Bishop graduated from Vanderbilt in 2015, where he studied political science, communication studies, and corporate strategy. Subsequently, he received his JD from Stanford Law School in 2020. During his time at Vanderbilt, Tyler served as editor-in-chief of The Hustler. At Stanford, he and Stanford law professor Pamela Karlan worked on the Altitude Express versus Zarda case with Professor Karlan's Supreme Court litigation clinic. Zarda, in conjunction with two other cases, resulted in a 6-3 Supreme Court decision in Bostock v. Clayton County in favor of Tyler's side. Tyler's Supreme Court litigation clinic team successfully litigated a case on the merits at the US Supreme Court, resulting in the holding that Title VII of the Civil Rights Act protects LGBTQ+ employees from workplace discrimination. Tyler also served as a law clerk for the Civil Rights Enforcement section of the California Department of Justice and the ACLU of Northern California. So Tyler, will you please tell us a bit about Bostock and your involvement in the case?
Yeah, absolutely. I'm more than happy to give a little bit of my insight, but I wanted to preface my comments just by saying that I am very passionate about the issues that came up in Bostock, and because I grew up in Houston, Texas, and moved to Morristown, Tennessee before high school, and as a gay man myself, trying to come to terms with kind of the realities of living in a non-welcoming community, as I kind of came to terms with my own sexuality. I had a lot of anxieties, as many young people do, about how that would play out throughout my life. So I'm really privileged to have had the opportunity so young in my career to have worked on an issue that I'm so personally passionate about. So as you mentioned, I went to Vanderbilt in 2011 and graduated in 2015. While I was there, I worked on The Hustler and issues of identity, race, sexuality, of course, as they are today, were very prominent in the discussions on campus and in the pages of the newspaper then. So all of this is very, very important and relevant to me and has been for quite some time. So after I graduated, I worked first at the Atlantic during the 2020 election, which kind of motivated me to ultimately make the decision to apply to law school. And in doing so, I kind of cultivated my passion for civil rights. And that's kind of what I focused my time at Stanford Law School on. And that's kind of what led me to the Supreme Court clinic. One of my mentors at the law school is Pamela Carlin, who's the director of that clinic. And while I was there, one of the cases that the clinic was trying to get before the Supreme Court was the companion case to Zarda, which is called the companion case to Bostock, which is referred to as Zarda, which is the name of a man who was a skydiving instructor who had been fired because he was gay. And so he sued his former company because of that. And I won't go into all the details of how it works its way up through the appeals process. But when it came to our clinic, it was at the Supreme Court stage. And the question presented in that case was whether the federal law, Title VII, that prohibits discrimination based on sex, also prohibits discrimination based on sexual orientation. And the Bostock case asked the same question about gender identity. And I won't go into the legal the legal questions there, because I know that will be covered later in the presentation. So I thought it might be most interesting for people to hear a little bit behind the scenes, what that process looked like, and kind of what goes into making a case before the Supreme Court. So in the clinic, the way that the case process works is that once the Supreme Court decides to take action on a case, it kind of sets that they will essentially set a briefing schedule. And so what we do is we kind of meet with some of the lawyers who have been working on the case. We meet with the clients. Unfortunately, Mr. Zarda, by the time the case had gotten to us, had passed away tragically in a skydiving accident. So he died doing what he loved, but we had the opportunity to work with his sister, who continued the litigation on his behalf, and our litigation partners at the ACLU, and his original attorney who had filed the original lawsuit several years previously. So what goes into that is a lot of roundtable discussions about how to make the best legal arguments. My colleagues in the clinic and I would do some of the initial drafting of the documents that you ultimately submit to the court. We worked with Pam Carlin, who ultimately argued the Zarda case before the Supreme Court on those arguments. She helped approve or kind of develop the arguments with us, worked with the clients with us, and ultimately, in October of 2019, the case was argued before the Supreme Court. So we spent a few days in Washington, D.C. doing last minute preparations and ultimately going to the court to make the argument. So we were, with any big case, the Supreme Court usually waits pretty late in the year, or at least in the year for the Supreme Court, which ends in June. So we're about to get our last Supreme Court decisions in the coming weeks, like we usually do. So last June, the Supreme Court announced its decision in our favor, written by Justice Gorsuch, who explained that when you discriminate against somebody because of their sexual orientation or because of their gender identity, you are discriminating against them from sex. And again, I won't go into the legal analysis right now, but that was the outcome of the case. We were very thrilled with it, and we think that it will have great implications going forward for the interpretation of similar language elsewhere. So I'll stop there. Hopefully that was a good overview of my background, why I'm passionate about this issue, and kind of my involvement in the case. And I'd be more than happy to take any questions that people have when we get there.
Awesome. Thank you so much, Tyler. And that is actually a perfect segue to talk to Dr. Shaw. So Professor Matthew Shaw is an assistant professor of public policy and education and an assistant professor of law at Vanderbilt University. He joined the faculty of Vanderbilt's Peabody College in 2016 after completing a postdoctoral fellowship at the American Bar Foundation. Sorry, a little noise there. He has a doctorate in education from Harvard University and a JD from Columbia University. Professor Shaw's forthcoming article in the University of Chicago Law Review entitled "The Property Interest in Education" examines the federal due process, liberty, and property rights all students have in education. His research centers the educational and labor market experiences of minoritized and marginalized communities, including undocumented immigrants, LGBTQ+ students, and historically Black colleges and universities toward a common goal of socio-legal liberation. So Matthew, what are your views on Bostock and the recent uptick in anti-LGBTQIA+ litigation?
Well, I'm a lawyer, so asking me my views is probably not the right phrasing. I can tell you what the case says and what are the likely implications. So there were 3 cases in Bostock. There was Altitude Express versus Zarda, which involved Tyler's client. There was Bostock versus Clayton County, which involved a gay man who was fired for participating in a gay softball league. And then there was Harris Funeral Homes versus the Equal Employment Opportunity Commission, which involved Amy Stevens, a transgender woman who was fired for transitioning. So those 3 cases came through. Fun fact for people who aren't lawyers, if you want to see something get to the Supreme Court, you pretty much have all of the elements here. You have the Second Circuit saying that Title VII does apply. You have the 11th Circuit saying that Title VII doesn't apply. And that's called a circuit split. And you can't really have a circuit split because we're supposed to have one single constitution with one single interpretation. So that's on the issue of sexual orientation. On the issue of gender identity, you have the Sixth Circuit. And whenever the Sixth Circuit takes a case, the Supreme Court is very interested because the Sixth Circuit tends to map very strongly on the demographics of the country, the lawyers and the judges from those cases. I mean, you're talking about Tennessee all the way up to Michigan, right along the spine of the Appalachians. So you're going to get some attention to those cases where you might not get attention to the same case coming from the Ninth Circuit because of California's influence, or the Fifth Circuit because of Texas's. So that's the big backdrop for Bostock. The big moment in Bostock actually was Justice Gorsuch's decision that discrimination because of sex has to, by construction, incorporate discrimination against, and in his words, homosexuals and transgender persons. There's a lot of erasure going on in that phraseology, but the basics are, I mean, this literally came down to basics. Who knew that prepositional phrases were more important than nouns? And that's effectively what happened here. He raised the empirical question, is it possible to discriminate against gay people or transgender persons without discriminating because of sex, to use the Title VII language? And the answer, of course, was no. Of course, that angered Justice Alito, who wrote the dissent, who said that the court was engaging in reformulating the language. But that has implications for a number of cases. Just last week, the Supreme Court issued a ruling in Fulton versus City of Philadelphia, where the court unanimously decided that the City of Philadelphia had not applied a law of neutral and general applicability to Catholic groups who were interested in maintaining relationships with foster care system in Philadelphia. I tend to agree with them, which might shock, but it's because laws of neutral and general applicability are probably the best safeguard we have for the moment when it comes to stopping what otherwise is an unfettered march of religious organizations who are trying to trample LGBTQI+ rights. So we saw it, for example, in Masterpiece Cake Shop versus Colorado Human Rights Commission. That case was not decided because the justices said that people have a right to discriminate, but rather that one has to apply a law of neutral and general applicability evenly across the board. Any exception to such a law means it's no longer generally applicable, which means it is a matter of discrimination and eligible for review. Typically what you'd be saying then is are you endorsing a viewpoint? Are you encouraging one viewpoint? And if it involves religion, then you might ask the question whether this is state-sponsored discrimination on the basis of religion, which is not allowed. What does this mean, broadly speaking? There's a lot of things going on right now. We have anti-trans legislation abounding. We have you have attempts to try to resurrect some of the marriage equality legislation. There is this din right now that we will not, that somehow Obergefell will be overturned. I don't think that's likely to happen, just stare decisis and the like. But here's where I think people should pay more attention. We should pay more attention to the cases that don't directly involve LGBTQI people, because I think that's the entryway. So any attacks on Roe versus Wade and the attacks on the general privacy doctrine is also an attack on all cases that have maintained our rights. And just to give you a flavor of those, we're talking all the way back from Romer, coming forward, Romer, Lawrence, Windsor, Obergefell. These all have privacy implications. So we need to be very careful about advocacy in those groups. The big shift right now from state houses focusing on critical race theory and that conversation will also have implications for education, for example, for LGBTQI plus students. It is taking the place in many places of the bathroom legislations that were dominating state houses recently. So these are so-called culture wars, to adopt language that's been used by a previous generation of scholars. But broadly speaking, it is the same. It's the same concept, the same fight. And that's, where do I see this going? I see that these fights will continue. I think we're eventually going to have a direct challenge to the legislations that the Religious Freedom Acts, both state religious freedom acts and federal religious freedom acts. And we need to be very prepared to have a conversation about what religious freedom is, independently of religious freedom to discriminate on the basis of sexual orientation or gender identity, because that is going to be the issue. We will likely need to bring in allies and co-conspirators to underscore what that is, so it doesn't become a shibboleth for we want to allow the state to discriminate freely against our community. So that's the one thing. The second thing is we have to protect trans kids. That's just got to happen. There's just no two ways about it. The Title IX conversation is going to happen in sports. That we have allowed this to, get out of the barn so quickly without really forcible, clear defenses of all of our students who want to participate in sports as they are, is a bit of a problem, and it's going to come back to haunt us if we don't get control over it. So I'll answer more in questions, but that's where I think the law is going.
Perfect. Thank you so much. So now we will move to Ms. Genius. Anita Genius is the director of Vanderbilt's Office of Equal Opportunity and Access. Ms. Genius has administrative oversight for all activities of Vanderbilt's Equal Opportunity and Affirmative Action Program, including the Affirmative Action Plan, Complaint Investigation and Resolution, and Disability and Religious Accommodations. She graduated from Vanderbilt with a BA in Political Science and Sociology. She earned her JD from the University of Tennessee, Knoxville, and completed further study at Bryn Mawr. She has also held administrative positions at the University of Pennsylvania and Tennessee State University. So Anita, can you tell us a little about your work as it pertains to supporting Vanderbilt's commitment to equity, access, and respect?
Absolutely. And thank you for that introduction. And it's such a pleasure to be here today with my esteemed colleagues on this panel. I'm just excited that we even have a panel like this, because when I graduated from Vanderbilt 1,000,001 years ago, there was no Potter Center. So clearly there were no panels like this that existed. So it has been wonderful to just see the evolution of the LGBTQ&I community at Vanderbilt, and the policies and procedures, and now ultimately the laws that certainly protect this community of persons. In terms of my office's involvement, we first saw an interest in really tackling discrimination in terms of the LGBTI community back in the mid-90s under Chancellor Joe B. Wyatt. The Vice Chancellor and General Counsel then was Jeff Carr, who wanted to add sexual orientation to Vanderbilt's non-discrimination statement. Now, keep in mind, this is at a time when, of course, there were no federal protections for LGBTQI people, and there certainly weren't any such laws in the state of Tennessee. I mean, let's be realistic. We are still very much a red state in that regard. So this was something that really was novel, especially for an institution like Vanderbilt at that time. So we did add protection for sexual orientation. Now, here's what was very different then from what's different now. Since there were no legal protections, we couldn't put it up in the section where we talked about all those other legally protected categories of race, sex, et cetera, because at that time, sexual orientation in terms of sex wasn't looked at as the same thing. So certainly one of the things that has happened more recently is that we've gotten to move that category up in the legally protected categories. I can remember having conversations with my LGBTQI colleagues and friends and explaining to them why, yes, why you're protected at Vanderbilt. Once you go outside these ivy colored, walls, those protections don't extend to you in terms of the state law. And yeah, somebody can fire you just because, you're a same-sex loving individual. We saw further development with the advent of the Potter Center and our first director, because at that time, while we covered sexual orientation, there was no thought to sexual identity and gender expression, which of course are very important categories as well for our community in that regard. So if we really wanted to have an active, thriving center that met the needs of our LGBTQI people here in our community, we needed to add those categories to our non-discrimination statement as well. And I remember really having some educational sessions with people, because at that time, persons really did not understand what the difference was between gender identity, gender expression, and sexual orientation. So we had a lot of education to do on campus just in terms of getting people up to speed in that regard. And again, as we see the categories change in terms of legal protections, we have certainly made those adjustments with our statement as well. I would agree with Professor Shaw, in terms of where we'll probably see some challenges. Of course, athletics is always huge, and that is a very controversial topic right now in the athletic community. And let's be realistic, this is an Olympic year. So of course, persons are going to talk about the trans community in terms of how persons compete and whether they should be allowed to compete. And I would agree with him in terms of our trans children, in terms of all children, we've got to be very protective of them and allow them to be all that they can be. Now, this is Anita's statement. This is not necessarily a Vanderbilt statement, but I'm a person who believes that if you belong to any marginalized group, you don't have the luxury of being discriminatory towards another. Okay, because all you have to do is fill in the blank. It can be Black, it can be female, it can be trans, it could be whatever particular religion that you practice. And there are persons out there who will think less of you because you fit in that particular category. So I like to think that we advocate for all groups, but particularly those groups who have historically been disenfranchised, who have been marginalized, who have been treated differently because of their status in a particular category. So to that end, I also agree with Matthew in that I think what we need to be looking for is not necessarily what is going to happen in this community or what are happening in some of those other areas as well, because ultimately it affects all of us in ways that we all realize if you just look at the history of civil rights in the country and how things have progressed. So we hope to continue this dialogue. We hope to continue working with our partners in this regard to make sure that Vanderbilt is a community that is inclusive and welcoming for everybody.
Thank you so much.
Thank you.
Last but certainly not least, we've got Rob. Rob Nelson is interim director of Vanderbilt's Office of LGBTQI Life and has been with LGBTQI Life since 2016. They hold a master's in theological studies with a focus in religion, ethics, and politics from Harvard Divinity School, a BA in religion and history from the University of Rochester, and an AA in humanities and social sciences from Monroe Community College. Their academic interests focus on the development of American religious identity constructions at the intersections of race, gender, and sexuality. Rob also has a passion for campus and community programming that engages these points of intersection. Additionally, they have given many talks and presentations nationally and locally covering the topics of the history of gender identity development and white supremacy, becoming an LGBTQ2S+ affirming church, overcoming religious trauma, and historical diversity in the LGBTQ2S+ community. Rob, can you tell us about your work at Casey Potter and what concerns students may have about entering the workforce as members of the community?
Absolutely. Thank you, Jay. First, I will echo Anita's thoughts on how exciting just having this panel is, and that there's a lot of campuses across the country where they're in states that are doing similar things to our state legislature, and these conversations aren't happening. So thank you to Lava and for hosting this conversation. I'm really glad we're having it. So we do a lot at our office. We support the entire LGBTQ+ community at Vanderbilt, includes students, staff, alumni, faculty, everybody. And we've done a few programs over the past few years designed to prepare LGBTQ+ students to enter the workforce or prepare to start like internships or something like that. And the main concerns that I consistently hear from them include, how to identify companies or institutions that are LGBTQ+ friendly, because not everybody has a non-discrimination policy right on their web page or something that's easy to find. And just having a non-discrimination policy does not necessarily mean that you won't experience discrimination. In fact, one of the other biggest concerns that students often share is not if they are discriminated against, but when they are discriminated against in the workforce, what do they do? Who do they go talk to? There's not going to be a Casey Potter Center at their workplace. So who do they go to? Do they go to the director of HR? How do they have that conversation? Because they go into it knowing that they're going to be discriminated against. And that is, I'm glad that we're having conversations honestly with them and keeping them informed and prepared for entering the workforce, but also makes me really sad every time I have to have that conversation with an LGBTQ+ student. And I often share some of the ways that I've navigated things and hopefully give them some advice that they can learn from things that other students and myself have experienced in the workplace. And so, all of these policies, all of the legislation that's being passed, or even attempted, every little bit piles on to the way that students think about what their life will look like when they leave college, right? And how do we both provide them with a sense of hope for their future, but also give them a sense of reality of what they are going to be facing. So that's a lot of what we work with students on, and also things like, how do they ask if a institution or organization has trans inclusive healthcare? And that means different things to different people, right? So you have to be educated as a trans individual going into the workforce. If you're looking for specific trans inclusive healthcare, you have to know what to look for. It's not enough to just ask, because that means different things in different states, right? And so having that conversation and preparing them to ask those questions, and when to out myself, because if you ask that question, you are outing yourself, right? If you share your pronouns on your resume, you are outing yourself. And so, that's a lot of the concerns that I hear from students. And all of these cases that are happening, that have happened, whether they're positive, or overall positive or not, every time a state bans conversion therapy for young people. It's a relief to hear, but it's also, if you're a person that has experienced conversion therapy, or you know people in your community that have, the fact that we're still waiting for this to be banned state by state by state, not only brings up your own experience with conversion therapy, but makes you realize that there are still thousands, if not millions, of LGBTQ plus folks experiencing that live in states that have not yet banned. So, even though we hear positive things like that, the fact that that has to happen adds another weight, another consideration for LGBTQ plus folks to carry with them as they leave campus. So it's a balance. It's a balance of how to instill hope, how to help them find what they're passionate about that will carry them through their professional life, but also prepare them so that they're educated and know what they're going out into the workforce and may experience.
Well, thank you so much. I think this is a good time to move into the Q&A. We've received some questions, but if anyone else has any others, please feel free to send them to us in the chat. So Anita and Rob, how has anti-LGBT legislation affected both the Vanderbilt community and higher education in general?
Well, I think Rob already kind of alluded to it, maybe somewhat unknowingly, in that it really has painted a certain picture for persons, particularly for young persons in our community who might be LGBTQI, in terms of looking at where they want to go to college, how friendly are those places going to be. Certainly for those, again, who are athletes who want to compete, am I going to be able to do what I love doing in this regard? If there is legislation being proposed that may prevent me from doing that, if I happen to be trans, for example. I think also that it opens our eyes, because you hear all these comments about we're a post-racial society, we're more open in terms of these things and that, but it shows us that we really are, in very many respects, traveling backwards in some regard, because of people's fear, because of their various isms. And again, you can fill in the blank. So I will put it to you this way. I'm probably the oldest person on the panel today. In fact, I would bet everybody's paycheck here that I am. And I have two young men in my house who are college age. The conversations we've had to have with them just in the past year, I never thought I would have to have with my kids, okay? And I'm a person who, being as old as I am, got to see the civil rights marches. Now, I was a kid, I was looking at the back of people's knees. I didn't know what I was doing. And, my grandmother had me by the hand. But as I got older, I was able to appreciate that experience and just knowing, what happened and what I lived through. So to see some of those things happening now, the insurrection, the anti-LGBT legislation, voter suppression, things of this nature, has really just raised my own awareness. And this is an area in which I work every day, that we have to be diligent in terms of making sure that we fight for rights for everyone. So I think in terms of what it's done in terms of affecting college campuses, it's just raised the awareness of young folk in terms of their need to learn how to advocate for themselves as well as others.
So just to add, Anita covered a lot of what I would have also said. So just to add a little bit to that, I would say that this has very real mental health implications for our LGBTQ plus students on campus. And I saw this firsthand, especially this past year with all the anti-trans legislation. And there's already enough that goes into deciding to fully express your gender identity and to share with people who you truly are, that then to also hear that the state you live in is trying to make it harder for you to do regular everyday things, and that essentially your identity and your validity as a human being is being discussed and legislated against on a regular basis in this state. And so that, that has direct mental health implications for anybody in the LGBTQ plus community. And we're talking specifically though about young people who are in a stage in life where they're trying to discover who they are. They're trying to explore what their passions might be that will carry them through the rest of their life. And so to experience something that has so much hate behind it at a period of time when you are creating the view that you will have about the world, it has a really negative impact on folks. And how could it not? So that's one way. The other thing that I will add is a lot of the anti-LGBT legislation, and I would say even broader than that, going back to what Dr. Shaw was talking about, is, a lot of these other things that are happening impact students on campus. So if we're bringing in students that are coming from states where critical race theory is banned, where they don't talk about gender or sexual identity, they don't talk about the history of racism in our country or slavery, they don't talk about the history of the LGBTQ plus movement or any civil rights movements, or they don't teach sex education. All of these things, we're bringing students to our campus that have come from states where those things are legislated against being taught, and asking them to participate in conversation on our campus that they don't have the tools to participate in. They don't have necessarily the tools or the frameworks to understand those. So we're at a point, and this has been happening for a few years, it's not a recent thing, but we're at a point where we're inviting our students to campus and hoping that they engage with each other in a way that is fruitful and equitable, and they don't have the tools and resources before they get here to be able to do that when they arrive. And so I think we're asking a lot of our students to both exist in a space where they're being legislated against, and also exist in a space where their peers don't understand the way that they live or who they are, right? So I think there's a lot happening there, and I know there's a lot of programs specifically at Vanderbilt that are really geared to addressing those moments when students first come onto campus and they start to meet new people that maybe they've never met folks that have those identities before. And so I know that's something that we work really hard to address, especially in first year, in the commons curriculum and stuff like that. But that's not always happening at all institutions, right? This is an issue for all higher education institutions. And I think we need to be a bit more transparent and honest about that as student affairs professionals, that when we engage with students who are experiencing these things, we need to be paying attention to also the states and the legislation and the culture and communities that they're coming from.
Excellent, thank you. I will pitch this one more generally to the panel. Are there any new upcoming anti-LGBTQ plus legislation in Tennessee, or even any national cases that the public should watch out for? If so, what can we do to help? How can we get involved?
I mean, there's so many. I mean, so you have variations on the current themes. You have public accommodations. I mean, so you'll have cases about public accommodations. Can I go and buy a wedding cake or a birthday cake or a pride cake? That, depending on how that goes, that could go, can I go into a store? I mean, no one's going to actually say, no LGBTQ people, we're not in 1950s Jim Crow South, though we are still in the South. But there are many ways that people can use dress codes, for example, to discriminate against people. There are many ways that people can just not sell things to you. They don't have to sell things to you and then say, well, I just didn't feel comfortable. So those types of things are things we should watch out for. Things that people don't pay as much attention to, and this actually ties back to what Rob and Anita were talking about, is it's the small things on the edges that people don't pay as much attention to. that can cause really tremendous and sometimes snowball consequences. States that make it difficult for people in our community to adopt or to participate in foster care services. Well, if people want to have families, they're not coming to Tennessee. And that's something that Vanderbilt can't actually do anything about directly. Wage differentials. We know that there are members of our community who do not make the same amount of money for doing the same amount of work. We have, and institutions tend to take advantage of that. I'm not accusing any institution of doing anything like that. I'm saying institutions, broadly speaking, do. If we think that someone has fewer job opportunities or is less mobile or is less competitive in a market, we don't tend to give them the same career opportunities, job promotions, salary improvements, and that has a cumulative effect economically and personally over a period of time. So that's something else we need to pay attention to. And that's likely to come up in fairly short order in employment law cases. I actually think that the legislation, the moves by legislators, if you go all the way back, and this is me being a big law nerd, go all the way back to Plessy versus Ferguson, the absolute worst thing you can do is put something and codify it into law. If you want a discrimination to go away, make a statute, because it might stand for a while, but it will fester by its own, under its own power. You can't actually say that the law allows gross discrimination in the ways that legislation tends to operate. Legislation it's very blunt, it overextends, it includes way too much without doing half of the things it says it's supposed to do. And so if you take the Plessy versus Ferguson approach to our rights, one of the best things that ever happened to us was don't ask, don't tell. It moved things forward very quickly. And before that, the anti-sodomy laws, and before that, just the gross discrimination that was codified. The LGBTQI civil rights movement has moved more quickly because of all of the attempts by state legislatures to put things into laws. But there will come a time that they will realize that this is a losing proposition, and then we'll have to deal with the day-to-day, the things that you aren't able to record on video, even with your smartphones, or where you're going to say, well, this is a matter of interpretation, and this wasn't really a discrimination on the basis of, gender identity or sexual orientation. This was just a discomfort. People have the right to just be jackasses. That is perfectly allowed under the law. And so you're going to get into that area. I think that's the thing that we need to be careful about. It's likely to be the thing that we will need to work on at Vanderbilt relative to Tennessee, both within our institution and as a leader within Tennessee.
Thank you. I have a question for Tyler. Did you work with any Amicus organizations on the briefing?
Yeah, so usually when a big case goes up to the Supreme Court, several organizations who have interest in the outcome will submit what's called an amicus to the court. That it basically means that there's that organization or individual or group of individuals provides briefing that adds context or additional points for the court to consider. And so in our case, there were dozens and dozens of organizations submitting amicus briefs on our behalf, or not on our behalf, but in favor of the outcome that we sought. And kind of from case to case, it may differ the extent to which the plaintiffs, the petitioners or the respondents, depending on the posture of the case, work with those organizations or individuals. And I think in our case, there were certainly a lot of the partner organizations that the ACLU in particular worked with. So the ACLU had a lot of involvement with coordinating that effort, as they often do in big Supreme Court cases. And so we definitely did a little bit of that work at the clinic with the ACLU, but we were primarily focused on our clients' briefing.
Yeah, thank you. Does inclusion and diversity also relate to university's faculty, administration, and personnel? And if so, how do these applicants for university employment identify themselves as LGBTQ without recriminations?
Well, I can answer that. Having made that decision when I applied. So employment law, I think actually this is new because of Bostock. And employment law should not allow people to be forced to disclose. And one can't use perceptions of identity in an employment decision. So that's actually a big deal. I think that's probably the biggest deal out of Bostock within the day-to-day things one can take and apply into one's personal life right now. So a person does not have to disclose. But Rob's point is spot on. There's so many ways that the disclosure happens inadvertently. There's so many ways that we want disclosure to happen. But even when we want to disclose, there are unintended consequences. There are spillover effects. Some are negative, some are positive. Some we want to have control over, even if they aren't necessarily desirable. For the most part, it is right now it's a cultural thing. It's an institutional culture thing, and that's just not at a university, but anywhere. If a person wants to identify, study the institution, study where you're applying, study if you want to work there. I chose to because one thing I did not want to do is to work somewhere where this was going to possibly be an issue. I tend to be an outspoken person. It kind of goes with being in public policy and law. I also tend to raise issues like when benefits weren't equivalent. Went right on up and said, hey, I know I'm walking in the door, but y'all need to fix your benefits. I'm not going to be able to do that if I haven't disclosed why this is important to me. But to Vanderbilt's credit, they have made steps toward equalizing benefits. It's not entirely right, but I mean, we're working on it. We'll get there. So some of this is about being who you are. I am comfortable being, a point person out there. And I think people take me, they take me as that. I can understand also why other people might not want to. It's a matter of coworkers and cultures. But legally, Vanderbilt is not allowed to have any recrimination, and I will let others speak about whether that is the case in practice.
So Vanderbilt actually has a number of their own internal policies that prevent discrimination based on gender or sexual identity. And I think, what Dr. Shaw said is right on. It depends. It sort of doesn't necessarily happen at the HR level. It's when you get into your departments and your offices that we tend to see on campus the majority of that discrimination still happening, or in the classroom. That's where a lot of our students experience it. So I think at like the initial hiring stage, it's probably okay to disclose at Vanderbilt. I say probably because that's up to everybody to decide for themselves, right? And I can't guarantee that you won't experience discrimination because it happens everywhere. But I can tell you that we've taken a lot of steps to make sure that that doesn't happen specifically at the HR level. And we do have a lot more work to do at the individual office and co-worker level.
I would agree with everything that Matthew and Rob have both said here today. One of the things that I would encourage is that, when you come to work, I would encourage you to be yourself. To the extent that you feel that you cannot, then you need to have some discussions with me, with HR, et cetera, because you're not going to do your best work as a student, as an employee, as a faculty member, if you cannot be yourself. Okay. Now, granted, we can legislate behavior. We can't legislate morality. But as I explained to people, once you cross Vanderbilt's gate, we have certain expectations in terms of how you are and you are not going to treat people. So to the extent that folk feel that they are being treated differently, we need to know about that so that we can address it. Because a small incident here or a small incident there, okay. But the more we learn about these things, we can identify pockets and where we need to address those things so that we can make sure that Vanderbilt is the welcoming environment that we want it to be. Another thing that came to my attention, and this is how people interpret things differently based on what they do. One area of concern, I think, certainly for myself as an affirmative action officer, is just how people choose to identify and when they identify. And as certainly, you know, myself and Rob and Matthew would know, you are relegated to certain categories, okay? When you come to work at Vanderbilt in terms of how you identify yourself. Now, please hear this, and this probably happens at other places as well. That is because the government only allows us to count people certain ways, okay? So for example, at the end of the day, when we turn in well, we don't turn them in, but when we count for governmental purposes, people, guess how we can count you? We can count you as one of two ways, male or female. That's it. There are no other categories. Now you can choose not to disclose that, but guess what? I still got to count you. The government tells me we have to count every individual that we employ, and we only get to count you as one of two ways, male or female. That's by governmental mandate. That is not necessarily by choice. So we are working to try to incorporate additional categories that allow people to identify in the way in which they choose, if they so choose. What we then need to figure out is how we incorporate that and still meet our governmental mandate. Of course, I keep hoping and wishing, you know, as some folks say, that the government gets on board and allows the proliferation of more categories so that we can count people correctly as well.
I have an idea.
Ooh, okay, I got my pen and paper, I'm ready.
Okay, so you just break the question apart. So you ask people how they identify and how they would like to be counted. You make them separate.
Yeah, so that's what I've suggested.
You project onto the government's issues.
Right.
The United States government, interestingly enough, has decided that one has to choose a binary. We do not endorse or not endorse this. We prefer for you to identify as you would like. But in order to comply with the United States government, we have to identify you somehow. So then you get to, and then you have the person say, all right, they'll choose. And if someone doesn't choose, then you have already disclosed that you're going to have to make a choice for them. But the more important thing is you still have the data about how a person actually identifies. So
right.
When we fix this mess, and this mess will eventually be fixed, we now will have historical data that will more accurately represent how people have identified throughout all of this period of time. And so we won't have the issue that often arises, especially when we're doing LGBTQ policy work, of we never had an idea of what gender identity was or how people may have identified, 10, 20, 30, 40 years ago. Vanderbilt will have that information, and it will give voice to people whom the government had tried to make silent.
Right. I agree with that wholeheartedly and have suggested just that thing. And if people don't want to tell us, that's fine too. There's always that category if I choose not to disclose, which I hate because I still got to count you. And I don't want to, have to pick and choose for folk, but it is what we do. But thank you for that.
Okay. We've got about 7 minutes left, so we might be able to sneak maybe 2 more questions in. Has Vanderbilt considered or employed school-wide surveys of discrimination experiences? If so, what trends have been identified? Putting you on the spot a little bit.
We've done a number of surveys school-wide that have had different motivations behind them and what they're trying to parse out. Not necessarily on discrimination itself, and how you would we survey staff and faculty differently than we survey students, and so we try to only do that as an institution enough times that we'll still get responses without overwhelming both of those populations, right? So it's a delicate dance in that. However, we do have some. We had a survey, and Anita could probably speak more to this, on sexual assault that we participated in. That was a nationwide survey. As far as faculty and staff, to my knowledge, no, that has not happened. But somebody can correct me on that if I am incorrect.
We have seen some information in terms of what I think the term of choice is climate surveys, where certainly, categories of people that you would expect says, yes, they've experienced, some differential treatment. There have been small numbers in terms of that. I think persons are concerned, in terms of whether they can be identified, even though it is not identifiable. But again, when you have, very a very small N of a group in certain areas, there's always that concern. So I wonder if people are really comfortable in terms of revealing that information. Because clearly, if I'm only the only African American or female or trans or whatever the case may be person in my department or in my school, even, I'm going to be much more guarded about really sharing that information than if I'm in a larger school where there are more people who identify like me. So I think there's some work to be done in that area, but we have to figure out how to do it in a way that still allows people to maintain their anonymity.
Yeah, thank you. I guess we'll do a lightning round. Closing thoughts, any messages you want to share with LAVA, with LGBTQ plus alumni or students? Any thoughts?
The university listens to alumni a lot more than people think. If there are issues, if there are things from your experience at Vanderbilt, if there are things that we need to do better, if there are classes that need to be offered, if there are perspectives that need to be included, let people know. And tie it to whether you will give money or not. Not that I should be saying this on a development call, but sure, why not? I'm an activist, so I do activist things. Y'all knew this when y'all got me on here. So activate. Make sure that you aren't just giving blindly, that the university knows who you are, what you stand for, and why it is important to all of its bottom lines, including demographic representation, because that's a way for us to be counted, particularly those of us who have my experience where I was not out in college. And I have since come out and been very vocal about why I didn't feel comfortable being out in college. It's a way, I think, for me and for, I suspect, many members of LAVA and even people who are not on this call or in this group to reconcile who they are with who they've been and where their institution can go going forward.
I'll add just two quick closing thoughts as well. The first is I want to just emphasize something that was said earlier about just when you go to work somewhere, you should feel comfortable being who you are. It's so important that you're able to thrive, because if you aren't feeling like you're able to do that, you're not going to reach your maximum potential. And I think that at the heart of our civil rights laws is what the employment discrimination prohibitions are all about. If we don't allow people to thrive, we're all gonna fail. So that's my first thing. And the second thing that I'll say is, right now we're at a moment in history where we're seeing a retraction of civil rights and in particular voting rights. So I would just encourage people to really pay attention to what's going on, not just at the national level, but also in the local and state governments. And get out there and be an activist if you have to, but our elections, our voting, all of this is tied together, and I think nothing could be more important than that.
Quickly, I would echo what Matthew said about alumni having a lot of power. That is incredibly true. So if there's something you care about happening at Vanderbilt, make that known. The second thing is you can do a lot with your voice if you do it locally. So if legislation wise, reach out to your local legislatures or legislators and contact them and tell them how you're feeling, what your thoughts are about some of the legislation that's happening, but do that locally. So reach out to your own senators or congresspeople.
Yeah, again, to reiterate what Rob and Matthew said, and I have to give credit for an older woman I heard say this one time. Her words were, "Put your money where your mortgage is." And that is be an advocate, be a voice in your own local communities, your council people, your state legislators, your local businesses, support LGBT businesses the same way you support other minority owned businesses. And I almost laughed when Matthew was talking earlier about the wedding cake, because when I read about that, my first thought was bake the cake anime. Don't eat the cake anime, bake the cake anime. I'm like, what? It's money. Money is green. What difference does it make? Where it's coming from. Let's all be in this together. But again, put your money where your mortgage is. Talk to your local government officials, your state officials. Be that voice. Be that advocate.
Thank you so much. And yeah, so I guess that will take us on home. We're a bit over time and want to respect everyone's time, but thank you so much to all the panelists for all of your insight. Thank you to everyone who's joined us. And of course, if you are not a member of LAVA and you want to join our ranks and get your rainbow flag mug, yes, perfect. There's a sign up link in the chat. Thanks again for your time, and we'll see you later. Bye.
Thanks for having me.